Hello, everyone, and welcome to Fact Fridays for June 13th of 2025. This is going to be another one of those presentations of lies versus truth, myths versus facts. There's been a lot of discussion recently about, are we legal? Have we ever been legal? So this week's topic is camp branch acres are legal status facts. And so this presentation clarifies the legal status of Camp Branch Acres Property Owners Association and addresses common misconceptions about our standing under Texas law. So let me just state, we are a legal entity. Before the unauthorized incorporation attempt, we were a unincorporated nonprofit association. After the unauthorized incorporation attempt, we remain an unincorporated nonprofit association. And I will go through the legal basis for this, references and citations throughout this presentation, but we qualify under Texas Business Organizations Code, Chapter 252, as an unincorporated nonprofit association due to our nonprofit purpose, which is maintaining the roads and like the boat ramp, the lighting of our community. Nobody goes home with a profit. Our formal documentation includes our recorded bylaws and CCRs, which establish member rights and governance. And the legal recognition from Texas is that we are a distinct legal entity without needing to file with the state. So let's go over the legal definition of an unincorporated nonprofit association as found in the Texas Business Organizations Code, Chapter 252. The Texas law definition states that a unincorporated nonprofit association is an unincorporated organization consisting of 3 or more members joined by mutual consent for a common nonprofit purpose. Now let's break down that definition. We're unincorporated. In fact, the property owners just affirmed that with the last vote that was overwhelmingly voting against incorporation. We definitely consist of 3 or more members, and we're joined by mutual consent. And this may be a sticking point for some because they don't want to be part of a POA or they want to see this POA go away, whatever. Well, when you either buy property here or you have it transferred to you or you inherit it, when the deed goes into your name, the POA runs with the land. So whether it's a realtor, somebody selling you a private sale, or a family member leaving it to you, they should disclose to you that there is a POA that is attached to the land. And that is their duty. That's not the POA's duty. It's the POA runs with the land. So when you gain land in any way or a home here in Camp Branch Acres, you have consented. And then for a nonprofit purpose, for a common nonprofit purpose. And our purpose is and always has been to manage the shared community resources like the roads and the boat ramp, security lighting, things like that. This has always been a nonprofit purpose, and it is widely recognized as a nonprofit purpose for POAs and HOAs. In fact, with the unauthorized corporation that Kelle Rahm and Kelle Rahm filed, their purpose, which if you read the directions for that corporate formation document, their nonprofit purpose mirrored this with managing community resources, including shared roadways. Now, it should be noted that no filing is required to be an unincorporated nonprofit association. You exist because you have a common nonprofit purpose, 3 or more members with mutual consent. That makes you an entity. In Texas, that makes you a legal entity. You do not have to file paperwork with the Secretary of State. You do not have to ask the IRS permission to be nonprofit. Hey guys, don't take my word for it. This is the actual Chapter 252 of the Texas Business Organizations Code, and you can see the address here. You can just Google Texas Chapter 252, and you'll find a link to this. Plus, I'll put links in the video description. So, at the very beginning here, nonprofit association means an unincorporated organization other than one created by a trust, consisting of 3 or more members joined by mutual consent for a common nonprofit purpose. Now, it states here a sentence, which I'll read to you in a minute. It just means that you're not an association just because you live with somebody or you share office space. So it says, a form of joint tenancy, tenancy in common, or tenancy by the entirety does not by itself establish a nonprofit association, regardless of whether the co-owners share use of the property for a nonprofit purpose. I'm going to scroll down to some interesting parts of it. Here's the statement of authority as to real property. The association can own property. Liability and tort and contract. Now, this seems to be a really big thing to some people here. So let's talk about this. A nonprofit association is a legal entity separate from its members for the purposes of determining and enforcing rights, duties, and liabilities in contract and tort. Subsection B specifically states a person is not liable for a breach of a nonprofit association's contract or for a tortious act or omission for which a nonprofit association is liable, merely because the person is a member, is authorized to participate in the management of the affairs of the nonprofit association, or is a person considered as a member by the nonprofit association. In other words, property owners are not liable for the association. They are not liable for the acts of the association, contracts of the association, or for anything else that they wouldn't normally be liable for just because they're a property owner in the association. And here's another important one. A member of or a person considered to be a member by a nonprofit association may assert a claim against the nonprofit association. A nonprofit association may assert a claim against a member or a person considered as a member by the nonprofit association. So just because you're a member of the Property Owners Association does not mean that you cannot sue it. I scroll down a bit. This is the capacity to assert and defend. Basically, as a separate legal entity, the association has the ability to sue and be sued and to be responsible for its actions. The other thing coming on down, books and records, you have to keep accurate records for at least 3 years. There is a discretionary filing. You can file to a registered agent to receive legal process for the association. It states that may file in the office of the Secretary of State. It does not say required or mandatory, anything like that. And in law, the word may and must are 2 very different things. I scroll down a bit because there's a lot of other stuff that, it's interesting. As you see, this is not a very long code. This is everything that applies to a unincorporated nonprofit association. So I'm going to scroll down to the bottom here, and this is the thing. Chapter controlling. Except as provided by subsection B, the only provisions of this code that apply or govern a nonprofit association are the provisions of this chapter. In other words, out of all this business organizations code, Chapter 252 is the code that governs unincorporated nonprofit associations. Now, because we are also a property owners association, we fall under Texas Property Code Section 209, but that's because we are an unincorporated nonprofit association that also became a POA. But as a unincorporated nonprofit association, this very small little chapter in the Business Organizations Code is all that applies except 1, 4, and 10. So the Corporation Code is Chapter 22. The unauthorized amendments filed by Kelle Rahm with our county clerk that tried to change our bylaws was based upon Chapter 22, the Corporate Code, which has nothing to do with unincorporated nonprofit associations. 1, 4, and 10 have to do with formation. They have to do with things like conversions, mergers, which, speaking of which, 252.018, mergers and conversions. This specifies that a nonprofit association may effect a merger or conversion by complying with the applicable provisions of Chapter 10 in the Nonprofit Association's governing documents. In other words, the unincorporated nonprofit association can only become a corporation if it goes through the conversion process that is outlined in Chapter 10 of the Business Organizations Code. None of that was followed. In fact, because we were already a nonprofit, you have to make a plan for how the resources and the funds and everything else are going to be converted from one legal entity to another. Even if the property owners had voted May 29th that they wanted to be incorporated, the corporation formed by Kelle Rahm and Kelle Rahm, I don't think it would have stood. It was not formed in the correct way. A conversion did not happen. They didn't follow the basic guidelines of what to do at the beginning of the corporate formation. Its formation was unauthorized, and its actions after that did not follow Business Organizations Code. So even if the property owners had voted to incorporate, we should have taken that corporation and just dissolved it, made it go away. Hopefully they would have done it themselves if they realized that they had messed up. And then we could start with a fresh corporate identity and go through all of the legal steps correctly with legal guidance. I have one other thing to show you about all of that. So we talked about the common nonprofit purpose. I just want to show you. This was the nonprofit purpose put in this unauthorized certificate of formation of a nonprofit corporation by Kelle Rahm, Kelle Rahm. Joe said he knew nothing about this. Travis won't really say. I think he said he couldn't remember. So coming on down, here is the purpose, Article 5 purpose. The nonprofit purpose that they filed was to maintain the aesthetics, property values, and overall quality of life within our community. The POA will act as a governing body, creating and enforcing rules and regulations that all residents must abide by. While that sounds a little authoritarian to me, the overall purpose is very similar to the purpose of our unincorporated nonprofit association. It's to manage community resources and to act as the governing body of the POA. Their nonprofit purpose is basically the same as our nonprofit purpose. So when they say we're not a nonprofit, you just have to look at Chapter 252. They define what an unincorporated nonprofit association is. It's 3 members, mutual consent, nonprofit purpose. Their purpose is essentially equivalent to the purpose of our POA as evidenced by our formation documents, our governing documents, our covenants and restrictions. And in fact, they even point out that Section C1 of our governing documents is the formation that was filed with the county to establish the POA. So that was the purpose of the CCRs, was to establish the POA. The same CCRs we've been using for many, 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 many years before they tried to incorporate us last year. And so this is a great pamphlet from the University of Texas at Austin Entrepreneurship and Community Development Clinic, the School of Law, and they're also a part of the Texas Access to Justice Foundation. This is a pamphlet that is aiming towards lawyers, explaining to them the difference between incorporated and unincorporated nonprofits here in the state of Texas. They put together on page 3 this very handy chart where it shows that the liability is the same. You see how it stretches across both nonprofit association and nonprofit corporation, these 2 columns. Liability is the same. Ability to enter into contracts is the same. Power to sue and be sued is the same. Governance is slightly different because they fall under different sections of the Business Organizations Code. Also, corporate formation. Corporate formalities like the UNA, the Unincorporated Nonprofit Association, doesn't have to have minutes and meetings and stuff, but as a POA, we do. And then funding may receive grants and donations, and that's on both sides. So the difference between a unincorporated nonprofit association and a nonprofit corporation really falls down to the business organizations code that it falls under and a couple formalities like how to do record keeping and stuff. There is not that much of a difference. And if you look at the liability, it's the same. Under Texas law, entity is recognized as a distinct legal entity. Leaders and members of the organization are protected from personal liabilities for the acts of the entity. I'm going to point out the leaders, the board members, are not free from liability for their individual acts that exceed the authorization of their office. Now, on page 5 of that same document, there's a little discussion here about determine the current legal status of the group. Is the group already an unincorporated nonprofit association? As you work through the pros and cons of each nonprofit entity choice for a group, you should also assess the current legal status of the organization. A grassroots group is likely to be in one of 3 stages. A loosely formed group that meets on a periodic basis to discuss and act on projects and issues. A group that may have some corporate elements such as bylaws, directors, officers, and periodic meetings, or a more tightly structured organization that meets on a regular basis, elects officers, has bylaws, and may have a board. So we meet that third phase of a unincorporated nonprofit. Then they go on to say, as noted above, the Texas Business Organizations Code defines an unincorporated nonprofit association as 3 or more people working on a common nonprofit purpose and doing so by mutual consent. The Texas Business Organizations Code does not require written documentation of intent or actions for a nonprofit association to be formed. This low threshold means that many grassroots groups are already Texas nonprofit associations, although many may be unaware of their legal status. Consider this a good news, bad news situation. So here was the good news. If a group meets the definition, it is automatically recognized as a legal entity in Texas. As a separate legal entity, the nonprofit association will have the following protections and powers under Texas law. A person is not liable for an association's actions simply because the person is a member or participates in the management of the association's affairs. An association can enter into contracts and acquire, hold, and transfer an interest in real or personal property. An association may sue or be sued. An association is able to form an attorney-client relationship. I scroll down, look at this bad news part. If a group meets the definition of a nonprofit association, it may also be automatically recognized as a tax-exempt organization under federal law and may be subject to reporting and filing requirements. Federal tax law will be discussed later in this guide. And this has been a big point of contention for some of the people that say we've never been legal, this, that, or whatever else. There are certain aspects that we are already considered tax exempt. And then there are certain aspects that if we wanted to push it to that point, we needed to file applications and things and such. The other thing is tax exempt and not owing taxes are 2 different things. There are some taxes that the Kellys and Phil are concerned about because there's not a formal tax exemption for us, but we fall under the threshold to even have to owe those taxes. So taxes is one of those things, especially as a POA, and we're trying to figure out things. A lot of things have been done by tradition over the years, and we have to remember the internet really opened up information for many, many people. We're looking back at years when the internet was not a handy tool. You couldn't just pull up these things online, read them, and then Google, explain this to me, explain that to me, and get a description of what the statutes mean and what the implications are and stuff. Back in the 80s, 90s, early 2000s, these resources weren't out there. If you wanted to learn about POA law, you needed to drive to Austin and go to a law library or pay an extraordinary amount for a law book through Barnes & Noble. And then on page 6, the brochure does some key pros and cons of nonprofit associations versus corporations. So the formalities are few for a nonprofit association. Dealing with outside parties may be a little bit more uncomfortable because sometimes bigger companies don't understand, especially from other states like California. They may not understand how Texas treats unincorporated nonprofit associations. And so sometimes funding may be a little bit harder. But with us, we're a small association in a small county in a small town, and we generally deal with small banks and small financial institutions. So, the guide for lawyers from UT Law talks about the key factors to balance are the ease of formation, operation, and dissolution, and a legal form that may be more familiar to third parties. The reason for choosing a corporation over a nonprofit association is generally due not to legal differences, but rather to third parties' comfort and familiarity with the corporation. As a general rule, the following groups are the only ones that need to think about forming a nonprofit corporation rather than an unincorporated nonprofit association. And so those are groups planning to apply for large grants, contracts, or certain government funding, groups that plan to work as community development corporations with more complex activities such as building affordable housing or operating a daycare center. So just to note, that's not a POA. That's like when we lived in Las Vegas, we lived in a place called Summerlin, and that was a huge Howard Hughes corporation. It was a master planned community. That's what they're talking about. Groups that plan to hire employees, which we don't have any employees. Groups that plan to acquire real estate that is potentially eligible for an exemption from ad valorem taxes. So our association is not going to be acquiring real estate, that they want to like not have to pay taxes on. I found this brochure to be very, very helpful, and so I will put the link to the UT Law working with grassroots groups, which grassroots just means small and close to the community. I'll put the link to this brochure in the comments of the video. So now we're going to listen to a very confused audio clip of Kelle Rahm at the Property Owners Association meeting of May 29th, 2025.
Next item, discuss and act on banking. I spoke with Ivan on Thursday, and he is giving us till tomorrow to pick up the checks from the bank. He hasn't been contacted or anything to try and resolve that. This vote is also going to because the vote came back to as do not rescind the forged document. And with the three bankings that...
Wait. There was no vote to rescind a forged document.
That's what this was.
No.
It was, do we want to remain a nonprofit, which if we were, then we would rescind the forged document.
That's not what that said.
Okay, whichever. We're a unincorporated association at this point. We are not an unincorporated nonprofit because we are not in any kind of nonprofit status. We haven't filed with the IRS. This company has not filed with the IRS. And in order to do so, you have to be a nonprofit corporation. You can't file for just to be a unincorporated nonprofit.
And so that was a little bit of a confused discussion about how we have to be incorporated to be nonprofit. We have to be incorporated to be tax exempt. We have to be incorporated. We're actually going to go into another about a minute of audio here where she explains, she reads the instructions for franchise tax exemption application for corporations. She reads that application and states that that means that we have to be incorporated to have tax exemptions. Please look at this UT Law thing again that shows eligibility for exemption from state and federal taxes is the same whether you're an unincorporated nonprofit association or a nonprofit corporation. She also stated in that clip that we could not possibly be an unincorporated nonprofit association. We are just an unincorporated association. We've already been through this. We meet the nonprofit purpose. The state of Texas recognizes us under Chapter 252. There actually is not a business entity in Texas called unincorporated association, because if you're not nonprofit, you're for profit, and there are distinct entities that people can, business structures that people can select from on the profit side. Unincorporated association is not one of those. And so here we come back to listen to the rest of the YouTube where she's just like, in order to have a bank account, we must have a franchise tax exemption, which I spoke with US Bank. They would be perfectly happy to be the bank account for our association. They just need a copy of our CCRs and an EIN. And I would recommend a new EIN because one of the Kellys just emailed all of the property owners the old EIN that Charlene has been working with the IRS to reactivate, the 1977 one. And Phil Cannaday disclosed both EINs in that Zoom call earlier this year. So at this point, they are both exposed. They're not secure. And we need to let the IRS know that in order to prevent a data breach, we need a new EIN for our unincorporated nonprofit association. So here is the YouTube clip again.
That being said, we have the bank comps are requiring that we have a franchise exemption. We cannot get a franchise exemption if we are not a nonprofit corporation. So we need to.
I'm not sure that's correct.
Okay. Homeowners exemptions from federal income tax or 501c4, which is what the HOA is. Otherwise, to receive a state franchise tax exemption, an HOA must be a nonprofit corporation organized and operated primarily to maintain, manage, construct, and maintain the property. But it says it must be a nonprofit corporation. That is from the state comptroller's office.
But wait a minute. What's that got to do with a bank?
Exactly. Oh, and by the way, here is from the Texas Comptroller website, the tax rates, thresholds, and deduction limits for franchise tax rates. No tax due threshold, $2,470,000. $2,470,000. Why do we need a franchise tax exemption? Now, if we were a for-profit entity, the bank would want to know that either we were paying our franchise tax or that we had a valid franchise tax exemption. That is not the case. In fact, let me go to the Texas Business Organizations Code. And so here we are back to Chapter 252 of the Unincorporated Nonprofit Association, the Texas Business Organizations Code. And I don't know if you know this on Windows or not, but I'm going to do Control F, which is a search box, and I'm actually going to type in franchise because she's talking about how that's required for unincorporated nonprofits, and no results. Now I'm going to type in IRS. And there's 8 results, but if you notice, it's all just pieces of words. It's the end of affairs, 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 affairs. Apparently there's a lot of affairs in unincorporated nonprofit associations. Here's just one more point to make. They keep saying that we aren't registered with the IRS as a nonprofit. Well, nonprofits don't register with the IRS. However, organizations that want tax exemption status do. And so most charities fall under 501c3, a lot of foundations fall under 501c3, and social welfare organizations fall under 501c4. But they're saying we can't be nonprofit because we're not we haven't filed with the IRS as far as a nonprofit status, which, once again, you wouldn't, but you would for tax exemption. I have the IRS search page here for tax-exempt organizations, and you'll notice Camp Branch Acres isn't there, but neither is the unauthorized corporation that was formed in 2024. So they're trying to hold the unincorporated nonprofit association to a higher standard than what they were willing to do with their unauthorized corporation. Okay, so let's repeat it once again for the cheap seats. Debunking common myths, the myth that we were just a contract. So this has a couple different forms. It's, no, it was just a partnership between members and the association. It was just a contract. It was a association, but not nonprofit. There's all these things. We were never just a contract between members. We've been a POA, and we've been an unincorporated nonprofit association since this POA was formed. The myth that there's no liability protection is just showing ignorance of Texas law. The myth that we must incorporate, you saw the chart of the differences between incorporated and unincorporated nonprofit organizations in Texas. There's very little difference, and for a association of our size, it's my opinion, but that's adding complexity in bookkeeping and other things that's not required for our boards that are primarily made up of volunteers. Nobody wants to spend that much time on this. And then the myth that if there's no tax ID without incorporation, and that's the same thing. You can't get a bank account, you can't get a tax exemption, you can't get a tax ID. An unincorporated nonprofit association is treated the same as a nonprofit corporation in the state of Texas as far as liabilities, rights. The only difference is the corporation is often easier to be recognized as a legitimate entity with bigger companies, or bigger grants, things like that. And the smaller ones, it's just less complicated, less overhead, less administrative burden to be unincorporated. So now we're going to dive into a little bit of case law. There was a hydropump lawsuit. I'm going to pull it up here after I go through this slide. The legal challenge was that hydropump did not actually complete the work that it was contracted to do, but it still wanted to be paid. And when Camp Branch Acres said, nope, you need to finish the work in order to get paid, they actually put liens on individual property owners' properties. Camp Branch Acres sought representation. They hired a lawyer. They filed a lawsuit. This was the right of an unincorporated nonprofit association to sue and be sued. This occurred while we were unincorporated, and the lawsuit described us as a nonprofit association, while at the same time they described Hydropump as a Texas corporation. So we were an unincorporated nonprofit association that was suing a vendor who had put liens on individual property owners' properties. And part of the lawsuit was that they can't put liens on the property owners' properties because, as members of an unincorporated nonprofit association, they were not individually liable for any contracts or actions of the association. So here's some great case law that shows that members are not personally liable for an unincorporated nonprofit association. So MT Falcon Investments versus Chisholm Trail Elks Lodge number 2659. An Austin Court of Appeals recognized a charitable bingo group as an unincorporated nonprofit association under Chapter 252, not a general partnership. The court emphasized that once the group met the unincorporated nonprofit association criteria, Chapter 252 abrogates the common law rule that members could be individually liable just because they assented or ratified contracts. The group was treated as a distinct legal entity, and members were not personally liable under contract. So even though they didn't realize they were an UNA, an unincorporated nonprofit association, they had the protections of it because they had already met the requirements for and Una. Now, this one holds a little special interest for me. The Christie Bay Temple versus Guide One Specialty Mutual Insurance Company. The Texas Supreme Court held that an unincorporated church retained its legal capacity to sue despite the existence of a later formed nonprofit corporation with the same name. The court emphasized it is not against Texas law to recognize the synod, which was the church, as an unincorporated association. This confirms that UNAs have legal standing and independence even when there's been a nonprofit corporation formed in their name in parallel. The third case is the Episcopal Diocese of Fort Worth. In a related ecclesiastical dispute, the Texas Supreme Court ruled that a diocese, organized as an UNA, was properly governed under Chapter 252. It affirmed that church governing documents could create legal capacity and independence without the need to incorporate. And we already looked at this grassroots. The UT Law's Grassroots Guide confirms that many grassroots groups are automatically recognized as a legal entity in Texas, although many may not be aware of their legal status. So the bottom line for Camp Branch Acres is case law in Texas confirms UNAs, which is unincorporated nonprofit association, are treated as independent legal entities regardless of formal registration. Individual members are not personally liable under Chapter 252 merely for membership or ratification of association contracts, and even if members don't know they are part of a UNA, the law still recognizes the entity and its legal protections. And so the conclusion is we are a legal entity, and the only reason why we've spent so much on this is because our current chair and secretary, former treasurer, keeps stating that we're not legal. The chair stated that we are a defunct association. We don't have nonprofit status. We've never been legal. We aren't legal now. People haven't done things legally, et cetera, et cetera, et cetera. And so I wanted to really explain and expand exactly why we're legal, the law basis, the case law basis, the interpretations from other legal resources out there to show that we're legal, we've been legal, we're going to remain legal, even in the face of their unauthorized incorporation. With the closure of that happened, it doesn't matter. Doesn't matter that the corporation closed, even if it was open. We saw with that case law with the church, just because a nonprofit corporation was formed in the same name did not take away the rights of the original unincorporated nonprofit association. So we're already legitimate. Camp Branch Acres is already a lawful protected association. We have the same liability protections as incorporated entities, and we're recognized under Texas law. It recognizes our status and our rights. So don't be misled by misinformation. The facts and the law are on our side. I am really disappointed in the chair, Kelle Rahm, and our secretary and former treasurer, Kelly Harrell, for continuing to put out misinformation in regards to our legal status. I can only assume that that's an effort to shut down this POA or coerce the property owners into taking their preferred course of action and incorporating. I want the property owners to be on guard at this annual meeting and just listen. Listen to what's being said. We should not put up with statements that we're not legal, we're not recognized, we're defunct, etc. We are a legal organization, and we're going to continue on. We're going to move forward. Thank you for listening. I can be reached at jenharristx@gmail.com or on YouTube. This is probably how you found me. I'm also one of the administrators of the Camp Branch Acres residence page, and I also administer the cbapoa.org website, which is the unofficial website that contains historical documents and current information for Camp Branch Acres. Thank you so much.